When Renee invited me to come this evening, she said in her email that this is not a traditional legal audience. That was, I assume, a compliment to you. And having heard Mr. Reed, I'm also confident that this is not the usual group of legal speakers that one hears in the kind of venues that I'm accustomed to speaking at. And I'm also unaccustomed to being accompanied by a piano player. Particularly one who I'm told when I go on too long is going to start playing. Believe me, when you're a judge, they never do that. Now, we're mentioned some notable cases that I had. I served on the bench for 21 years and heard probably 250 to 300 trials, probably had 8,000 or so cases. I'm not going to talk to you this evening about the ones that were mentioned, or probably any cases that you ever heard anything about. It's a criminal case. The defendant in the case was a lawyer. He'd been born of Eastern European parentage, grew up in the Central Valley, was bright, energetic. He graduated from the University of California and went on to law school at the University of California. He came out and he joined a prominent and very respected plaintiff's law firm and practiced there for a few years and then went out on his own, where he was very successful as a plaintiff's lawyer. Now, one of the things that you need to appreciate in connection with the case that unfolded is that a plaintiff's lawyer's income is very sporadic. Unlike lawyers who work by the hour and who are paid regularly or who are salaried, a plaintiff's lawyer typically is paid by some percentage of the recoveries that he or she makes on behalf of clients. And because those recoveries occur only from time to time, there are high points, low points, dry spells in a plaintiff's lawyer's income. And one of the other things that's crucial to a plaintiff's practice is the maintenance of what is called a client trust account. Because these recoveries are on behalf of clients, but when they are recovered, there are oftentimes claims against those funds for expenses, for the attorney's fees, perhaps insurance carriers have a claim to some of those monies, or other parties. The lawyer is required to maintain those funds separately from his own funds in what is called a client trust account. The defendant in this case, successful lawyer that he was, enjoyed a very rich lifestyle. Too rich, as it turned out. He had a mansion in Pacific Heights on which he had borrowed a great deal of money and which carried a monthly mortgage payment of $37,500 a month. He had a yacht. He enjoyed a fairly lavish lifestyle. He stayed at expensive resorts. And the money that came in the law practice didn't always cover all of these personal expenses. And so he started the practice of taking money out of that client trust account and using it to support his own lifestyle. And of course, once you start a scheme of that kind, eventually it's going to unwind on you. And it began to unwind on him. Now, this is a storytelling venue. And one of the great things about a courtroom is that it too is a storytelling venue. And this case is really a story within a story, or stories within a story. Because the evidence in the case came from the clients that this lawyer had represented. The first were a group of farm workers up in Napa Valley that he had represented in a case against landlords who had provided substandard housing. And on behalf of this class of farm workers, he obtained a recovery of $2 million, which went into the client trust account. And after all of the expenses and other appropriate deductions were taken out, there remained in the client trust account for the plaintiffs themselves $1.3 million. But by the time the plaintiffs started seeking their money, there was less than $800 in that fund. The McCoys, Jim and Molly McCoy, who had a son, Anakin, who was born at the Alta Bates Medical Center in the East Bay. And because of malpractice on the part of the medical center, he contracted a very serious neurological disease. The lawyer represented the McCoys against Alta Bates and recovered a substantial amount of money. But when the McCoys went to obtain their recovery, there wasn't enough money in the client trust account to satisfy those claims. And there was Dr. Ferry, whose adult daughter was thought to have psychological problems. She was acting erratically. She was lighting cigarettes and putting them in her mouth with the lighted end first, among other things. Dr. Ferry took this daughter to UCSF Medical Center. They thought the daughter had psychological problems and referred her to the Langley Porter Institute next door, who thought, no, she had medical problems, and discharged her. Well, she acted even more strangely until eventually she was taken to San Francisco General, where they diagnosed a real problem. But a problem that had grown far more serious because of the failure of UCSF and Langley Porter to provide care for this young woman. And Dr. Ferry obtained a substantial recovery, and she too was unable to obtain it because when she went to obtain these funds, the funds had already been spent out of the client trust account. And there was Mrs. Gershkin, who slipped and fell at her synagogue and contracted serious injuries. She sued, obtained a substantial recovery. But like the others, when she went to claim what she was entitled to obtain, it wasn't there. And then there was the story of Patrick Conway and his wife. Patrick Conway was born in Ireland. He came to the United States, studied engineering, had a good job with a Silicon Valley company, married, and he and his wife, over the first 13 years of their marriage, tried very hard to have children, without success. They went to Stanford. Stanford referred them to a fertility clinic in San Francisco. In the course of this effort to have children, of course, Mr. Conway underwent many tests. And one of these tests disclosed that he carried that gene, which when united with a carrier of a similar gene, will produce an offspring with cerebral palsy. He disclosed this condition to the fertility clinic, told them, be sure to test the egg donor for the presence of this gene. The fertility clinic had suggested that because Mrs. Conway was having difficulty, in fact it was impossible for her to conceive, that they should accept a donor egg to be fertilized in vitro by Mr. Conway's sperm. That was done. The egg was transplanted into Mrs. Conway. She was pregnant after all of this time of trying to become pregnant. The Conways thought that they were realizing their life's dream. Mrs. Conway gave birth to twins, 2 little boys. Both had cerebral palsy. In the first year of the little boys' lives, the Conways' medical expenses were $3.4 million. They were confronted with the emotional, physical, and financial difficulties of this situation. They went to this lawyer to seek redress. Among other defendants, of course, he sued the doctor at the fertility clinic and eventually agreed to a settlement for the full amount of the doctor's malpractice coverage, which was $1 million. The $1 million went into the client trust account. But like the others, when the Conways went to claim what was due them, it wasn't there. Mr. Conway discovered this, fortunately. He took the case to another law firm, a reputable law firm, which pursued other defendants, and fortunately, in his case, because the Bank of America, which held the client trust account, had negotiated that settlement fee check without Mr. Conway's signature, they were liable for the full amount. And so, for Mr. Conway and his wife, there was no financial loss as a result of this. But the emotional toll, the tragedy of having had one tragedy compounded by the wrongdoing of a person whom they placed their trust in, was a very grave injury indeed. At the conclusion of the case, of course, the defendant was convicted. He was sentenced to a very long sentence. And so some slight measure of justice was done. But nonetheless, the toll didn't end for these people who were victims of one kind of tragedy, because they placed their trust in somebody who abused it in a most tragic way. That happens in our system. You've heard tonight some people tell you about how important it is to try to make this system of justice work as best it can. It's very important, whether you tell the story in anecdotes or otherwise. So when you receive that jury summons, when you're called upon to participate in this system, you should do so with your good common sense and see if you too can't bring a little bit of justice back to people who very often deserve it very badly. Thank you.